Okay, ladies and gentlemen, if you wouldn't mind taking a seat, please. We are very excited. We've just started live broadcast streaming for the very first time here at the University of UOW Library, and it seems to be all systems go, which is very exciting because sometimes these things can fall over, but we're hoping to have some engagement online, which would be wonderful. So we'll just get people to take their seats quickly. If you want to come and stand beside, or did you want to take a seat for a moment, Professor? If you take a seat for just a moment next to Professor Chikara, and I'll bring you up in just a moment. We have a couple of seats over here. Yeah, you won't be in the way. It's okay. You're nice and low. Okay. Well, today I'd like to begin by acknowledging and paying my respects to the traditional custodians of this land which are gathered here today. We would also like to pay my respects to elders past and present and extend that respect to all Aboriginal people that are present here today as well. So thank you for joining us. We're very excited to have this presentation. We have our esteemed Professor Emeritus Edward that's here to talk about his reflections on being a part of the constitutional development in Papua New Guinea. We also have his lovely wife Kerry joining us. Special guests include Professor Joe Chikara from the University of Wollongong, who's our Deputy Vice-Chancellor. We also have Consul General Samarkand, I think I've got that right, from the Papua New Guinea Consulate in Sydney, and our Director of Library Services, Naji Chanti. For guests who are also joining us via our live stream, hello and welcome. You can actually tweet questions later on, and we'd love to welcome you to do that. Our hashtag is TEDWPNG. And our library handle is UOW Library. I think it's the first time Professor Wilkes has been hashtagged. We wondered if that was a rude comment, but it's not. We're hoping to field some questions from online for him as well. Also, if hearing the presentation today brings up any memories or you have any comments or stories that you would like to tell, please go to our library Facebook page and our event page that we have listed there with Professor Wilkes' talk. We'd love to have some feedback from you there as well. So, Edward, who we call Ted fondly, Wilkes, completed his Bachelor of Arts First Class Honours in Government and Public Administration at the University of Sydney in 1964. In 1965, Ted travelled to Papua New Guinea for a teaching position, unaware that this initial visit would be the foundation of a lifelong fascination and association with Papua New Guinea. In 1967, Ted was awarded an Institute of Current World Affairs Fellowship, which funded 5 years of residence, travel and writing in Papua New Guinea, Solomon Islands and Irian Jaya. Returning to Australia in 1972, he became a foundation lecturer in politics at Macquarie University and was then invited to serve as a permanent consultant to the committee charged with developing a constitution for Papua New Guinea, an independent Papua New Guinea. Ted earned his PhD in Political and Administrative Studies from the University of Papua New Guinea in 1975. Following examination of his first book, Race Relations and Colonial Rule in Papua New Guinea, it was the first PhD to be awarded in Political Studies at the University of Papua New Guinea. Professor Wilkes joined the University of Wollongong in 1987 as the Foundation Professor of Politics and has been serving at this university for 27 years in roles, probably more than that now, spanning research, teaching and curriculum development, politics, government and public policy, international relations, constitution making and constitutional development, national sovereignty and the role of women in these spheres. Ted Wilkes has been engaged by successive PNG governments and was the National Government Advisor in the Bougainville peace process. He has served on the United Nations Panel on Opportunity and Participation as an expert at regional seminars of the UN Special Committee on Decolonisation, been involved in World Bank roundtables and parliamentary committees in Australia, New Zealand, Papua New Guinea, the Philippines and Solomon Islands. We welcome you here very warmly today, Professor Wilkes, to share your reflections on being part of the constitutional development of Papua New Guinea.
General Sumasi Singh, let me first say how much I appreciate the honour of your coming here to join us today. Thank you very much. Professor Chicharo, ladies and gentlemen, thank you very much for your interest. What's been a lifelong interest of mine. As I've been invited to offer reflections, which is a rather personal matter, at university, and I'm accordingly uncertain about the appropriate balance between the personal and the academic. This presentation will be a mixture. So let me begin by recording my reflections as I left Mr. Hubert Murray Stadium, named for a long-serving Australian Lieutenant Governor of Papua. At the conclusion of the official ceremony, at which the Australian flag was lowered and handed over to the Australian Governor-General Sir John Kerr, a man with long-standing connections with Papua New Guinea going back quite a while. And of course, himself a major actor in an important constitutional consultation a few weeks later. In fact, one of my memories is as I walked through the car park to see Malcolm Fraser looking for a car, so to go back to his hotel shortly after the Governor-General and Doc Whitlam had left him as part of the official parade. The thought going through my mind was that although I believe very firmly in what we were trying to do, almost everywhere else in the recently decolonised world, there were now one-party states where there had been military coups. And I remember thinking as I went down the steps, despite my belief in what we were doing, would I even be allowed back in Papua New Guinea in 10 years' time? There seemed little reason, if one believed in comparative politics, to suppose that that was possible. So it's a very particular privilege and occasion for reflection to look at the achievement now of 40 years of constitutional democracy in Papua New Guinea. Tomorrow will be the 41st anniversary of Papua New Guinea's independence. Also the official calendar of public holidays in Papua New Guinea, reports in the media and public opinion seem to suggest. However, not everyone seems to agree, or at least to accept the terms in which Papua New Guinea's independence is widely regarded. A pioneer in Papua New Guinean historian, Professor John Waiko, has recently suggested in the media that linguistic, archaeological and geological evidence shows that Papua New Guinea has been independent for 49,000 years. The country was independent before coming together to form a nation, so he said. When one recalls the ongoing pressures for recognition of diverse ethnic, provincial and regional identities in Papua New Guinea, and in some cases across borders with communities in neighbouring countries, the most one can say in response is that the Constitution of the independent state of Papua New Guinea provides a framework for forming and acting as a nation, while also committing the state to respect for Papua New Guinean ways, providing an institutional framework which recognises and facilitates the expression of subnational identities through provincial and local level governments, and in the case of Bougainville, the form of autonomous government, the constitutionally guaranteed referendum on the political future due to be held between 2015 and 2020, in which a separate independence for Bougainville is an available option. In this regard, too, I seem to recall that it's important to recall the caution that some Papua New Guinean leaders, prominent leaders, felt about the proximity of independence. I remember shortly before independence, meeting in Sydney with a very prominent and nationalist leader who, when we saw a newspaper headline that Papua New Guinea will shortly become independent, started physically shaking in fear. So it was a very complex phenomenon. A recent experience of mine might also help to illuminate some of the complexities of building a national independence in Papua New Guinea. As even casual visitors to Papua New Guinea are often quite quickly aware, a frequent practice when meeting someone for the first time is to ask them where they're from. You will know where. Let's believe where. Where once the answer tended to be the name of a village, a language group, or a local administrative entity, increasing intermarriage and other interactions across previous differences and divides mean that young persons are increasingly likely to reply to the question, where are you from, with an answer such as Simbu and Oro, Sepik and Central, or other combinations that do not refer to any particular place. Their answers are framed with reference to their parents' places of birth, upbringing, or other identification. Perceptions of self and others can also be framed in regional terms, such as Highlander, coastal, islander. Not so long ago, I had the experience of enjoying a conversation with a young Papua New Guinean student who had departed thanked me, very much to my surprise, for not asking where she was from. A question I hadn't even thought to ask. In other words, there is an increasing number of people who see themselves primarily, perhaps even exclusively, as Papua New Guineans. So Papua New Guinea is changing. Not only is the economy growing and diversifying, but particularly young people's sense of identity is changing too. Growing numbers of Papua New Guineans, irrespective of their parents' places of origin, not only speak Talk Pisin, it is with increasing frequency their first language. In parts of the country where people get angry if you spoke to them in Talk Pisin, saying, that's not our language. That is now very largely frequently the lingua franca. And the vocabulary of English is changing too. So people can refer directly to a spring bag as a bilum, beetle nut as buai, and so on. However, in spite of, or is it because of the changes occurring in many different aspects of life in Papua New Guinea, the constitution of the independent state of Papua New Guinea remains in place, but amended by the National Parliament in accordance with constitutional requirements, interpreted in fresh ways by the courts, and adapted as administrative and other practices evolve. In fact, the Papua New Guinea Constitution is now one of the 40 or 50 oldest national constitutions still in place among the 190 plus independent countries in the world. Systematic comparisons of this kind are difficult to make because of processes of constitutional amendment, how effective you think a constitution is, and so on. But the global average for the lifespan of constitutions, according to some scholars, since 1789, is about 17 years, and the median is about 18. The averages in Latin America and post-colonial Africa are very much shorter, 12.4 and 10.2 years respectively. So why is Papua New Guinea's achievement of 41 years of constitutional democracy such a distinctive achievement? The answer could probably be found in the country's constitutional development, the way in which the constitution was made, how challenges of various kinds have been addressed, and how the constitution has developed as a result of amendments, judicial interpretation, and so on. When we look at how the constitution was made, we can see right at the beginning of the constitution, in capital letters, we, the people of Papua New Guinea, hereby establish, adopt and give to ourselves this constitution to come into effect on Independence Day, that is the 16th of September 1975. It goes on to declare 5 national goals and directing principles: integral human development, equality and participation, national sovereignty and self-reliance, natural resources and environment, and Papua New Guinean ways. The titles alone emphasise the national origins and purposes of the Constitution. The detailed provisions continue to be cited in, and so many people hope to inspire, successive national development plans and policies. In the lead up to independence, the respective constitution was generally translated into Tokpism as Arts Law on Government, the basic law of government. It is now called, increasingly, the mother law, the framework in which Papua New Guinea is governed and developed. The opening reference to we the people is not mere rhetoric. The Papua New Guinea Constitution was legislated legislative following a process in which people around Papua New Guinea were actively engaged. And that process helps to explain why the constitution wasn't finalised as quickly as the then Papua New Guinea government or the Australian government hoped. The consultations, the public consultations, were arguably amongst the most inclusive employed in the preparation of a national constitution anywhere in the world. To some extent, the process drew on precedents set by previous select committees in Papua New Guinea, by the way in which the United Nations visiting missions used to tour New Guinea, but not the Papuan side, of course. And these may have, obviously had an impact on the very idea of consulting with people. The first Papua New Guinea-led government, which took office in 1972, established the Constitutional Planning Committee with the task of proposing a draft constitution. In the words of the then Chief Minister, later Grand Chief Sir Michael Samari, and I quote, "It is for our people that a constitution will be made. It is our people who shall have to live under the system of government that is established. We must ensure, therefore, that the constitution is suited to the needs and circumstances of Papua New Guinea and is not imposed from outside. In short, it should be a homegrown constitution." The commitment to a homegrown constitution had several different dimensions. They included the CPC's Constitutional Planning Committee's composition, which included equal numbers of government and opposition members, people from all major regions of the country. It involved a determination to ensure that the constitution would not be imposed or imported from outside or negotiated over the table with the departing colonial power, as was generally the pattern in other decolonising situations. And it was a commitment that the constitution would not be enacted as a law of Australia, but that the laws of Australia would cease to apply unless some were accepted in Papua New Guinea at independence. And again, this is different from the pattern in many other post-colonial situations where the constitutions are actually orders in council of the British government or laws of foreign countries. The laws of other countries can apply if they're adopted in Papua New Guinea, and the constitution contains a list of such laws, and foreign judicial interpretations and legislation continue to have an influence, particularly on the judiciary in Papua New Guinea. The members of the Constitutional Planning Committee were all Papua New Guineans. They did not include the expatriate or Australian members of the House of Assembly. And as I said, officially the leader was the Chief Minister himself, Michael Samari is the chair, and the chairs of two previous select committees, John Pies and Paul Zarek, but they didn't actually go to meetings. In practice, the Deputy Chairman, then Father John Womas, now the President of the Autonomous Region of Bougainville, was the leader, the Chairman of the Constitutional Planning Committee. The result of its representative nature meant that some of the members of the CPC, being part of a cross-section of the community, had not had much access to formal education, not because they were impossible to educate, but because there were no schools in their areas. And so it was important that they be provided with translators and interpreters, at least into the other two major national languages, to help them participate actively in the meetings. And there's a story that's been told a few times of my role in interpreting for one of them, a very distinguished, and I think very, very intelligent leader from the Southern Highlands. But when we got to our terms of reference, we got to administrative review tribunals and ombudsmen. Those things didn't exist, even in most of Australia at that stage. So I carefully said, we're coming now to administrative review tribunal, one-time ombudsman. And he looked up at me and he said, "The one of you like putting Bushman on constitution, maybe got plenty locales." In other words, why are you putting a Bushman in the constitution? The terms of reference for the CPC staff included a commitment that they would be responsible solely to the CPC. and a requirement that they would be people who saw their task as assisting the members of the committee to give concrete expressions to the members' ideas. Western Samoa provided a powerful precedent for preparing and enacting a homegrown constitution. It was one that certainly inspired those of us who were aware of it. But Samoa was a territory, as it enacted its constitution, with one language, a fairly integrated social structure, and so on. So the idea that you could do the same thing in Papua New Guinea, a country with 860 plus languages, we're still finding out exactly how many, with no centralised authority structures, generally even at the local level, was a true challenge. And the practical way forward was to consult. And the consultation process, which the CPC engaged, involved the establishment of some 400 discussion groups comprised of 8,000 community leaders around the country, except in Bougainville, where support for secession meant that the Bougainville Special Political Committee claimed to speak for the people. The discussion groups were provided with 6 successive discussion papers to which they were requested to give consideration and provide responses. And these discussion papers were provided in all 3 national languages: English, Portuguese, and Hiriwatu. The topics they addressed in order were citizenship, relations between the central government and other levels of government, executive and legislature, the courts and law officers, the public service and the ombudsman, human rights, directive principles and emergency powers. All of the discussion papers have the committee's insistence posed questions, not options. How can we decide who is a citizen? Should a person be able to be a citizen of Papua New Guinea and of another country at the same time, and so on? And in that respect, again, they differed from counterparts in other countries. I know when I subsequently worked, for example, with a committee in the Solomons, and I tried to ask these questions, people just said, no, we want options. We can't do it this way. In Papua New Guinea, this was how it was done. In addition to discussion groups' responses to the discussion papers, the CPC invited and received some 500 written submissions from individuals, groups and organisations around the country. These inputs were addition to the advice received from the 4 permanent consultants, the legal advisors and other experts, including some with experience with decolonisation in other parts of the world. The CPC itself pressed for a Papua New Guinean to be appointed as one of the permanent advisors. It believed that a homegrown constitution didn't just want foreigners to be providing advice, and the person appointed was the late Bernard Moore-Marikobi, who was amongst the first Papua New Guinean university graduates, and of course the author of quite a few works on the whole concept of there being more than one. In addition to public meetings and discussion groups' written responses, the CPC invited and received 5 of these written submissions. It often got less formal and quite different advice, but revealing inputs into the consultation process as we toured the country. It included, for example, the hostile reactions of some expatriates to some of the Papua New Guinean members of the committee. I can remember when we were in Baroka, the late Sir Barry Holloway taking us to a club and going around and saying to a whole lot of foreigners, should we say, who do you most hate in Papua New Guinea? And they would invariably say Momus and Capricorn, and he would say, would you like to meet them? They're just here. There were passionate demands in some places for expatriates not to be accepted as citizens or even as continuing residents, but to leave an independent Papua New Guinea. I remember at Lamangai in Hanover, where is now the New Island province, people getting up and saying, you talking more master, oli raus, oli cleaner, oli loose people. In other words, tell them to get out. We don't want them here. And there was certainly, it wasn't like that everywhere, but there were places where people felt that very strongly. And it's an interesting juxtaposition to a more recent meeting I went to in Canberra when the Prime Minister of Papua New Guinea announced that he was introducing dual citizenship, and the Papua New Guinean students there all cheered and clapped and smiled because it was no longer about continuing domination of foreigners in Papua New Guinea. It was about Papua New Guineans having opportunities to go abroad. A very different situation. There were also enormous pressures for greater decentralisation, policy making, public services and infrastructure, for economic activities and opportunities. CPC considered all of these inputs and submitted 2 interim reports and then a final report to government for presentation to what's then the House of Assembly. And there were briefings also for other government officers. The final report drew on precedents in many other countries, but many recommendations were unique. They include the recommendations to include national goals and directive principles in the Constitution. I can remember being in my car one day with President Motley, now President Momas, and he started talking about putting social goals in the Constitution. And I thought, I've never heard of this, never seen a Constitution with this. But out of that evolved, partly drawing on not precedents, but attempts at not dissimilar activities in 1 or 2 other countries, the national goals and directive principles. They're both human rights and basic social obligations, which again is, I think, probably unique in the world. And on the one hand, drawing on experience, they also drew on the Westminster model, which was the system of government people knew, but there are quite unique aspects to it. So that a motion of no confidence in the government must name the person who is to succeed as Prime Minister. You can't go through the situation in many other countries. There has to be a specified time in advance and a certain number of people signing the document and so on. In addition, there were debates, of course, in the Constituent Assembly, which was the House of Assembly reassembled to finalise and adopt the Constitution. And I think it's important to bear in mind that the Constitution itself contains a provision which says that these debates, these reports should be used as aids to interpretation of the Constitution. So the Constitution is not just a matter for legal technicalities. The purposes of the people who are making it are important. So, of course, as I think I've implied before, those purposes might differ from those of people nowadays. But what is quite striking is that even in the academic accounts of the Constitution, the only document ever cited was the CPC report, which was one I was involved in ignorance of the fact that some of the most dramatically unusual recommendations were not accepted by the Constituent Assembly. In other words, it was a very multiplex process through which it emerged. Following this, the Papua New Guinea Constitution might be 40 years old now, or 41 years old, it's not static. It's been subjected to extensive review from time to time. The text has been amended at least 42 times. Its provisions have been elaborated, and the elaborations themselves amended in 21 organic laws, as well as ordinary legislation, regulations and procedures. And the courts continue to interpret the Constitution in sometimes quite unusual ways. Particular difficulty with all of this is that it's almost impossible to get a completely authoritative version of the Constitution. The one I've got points out in footnotes that certain provisions have been amended or discredited or regarded as invalid by the courts. But what is the situation now? And the major regional website for doing research in the Pacific, one which I use almost every day, also contains 2 inconsistent versions of the same organic law, with no way of telling which one to use. I say this not as criticism, but just, I think it possibly could be the case that the law has become unknowable, but because of the need to pay attention very carefully to these matters. The courts have, I think, come up, particularly in recent years, with some really innovative and, to me, unexpected and unprecedented kinds of decisions. In the special reference by the Fly River Executive Government on the organic law of the integrity of political parties and candidates in 2010, the court held that an amendment to the Constitution, which had been made in accordance with the constitutional process, was nonetheless invalid because it violated fundamental constitutional principles. And those principles had to do with the accountability of members of parliament to their electors, their responsibility to make decisions for themselves and so on, and not simply to take party orders. I thought that was a truly innovative decision. Another instance, the full text of which unfortunately doesn't appear to be available online, was the case filed in 2015, in which the Supreme Court found that the passage of a constitutional amendment increasing the grace period between motions of no confidence in a Prime Minister and changing the other rules for changing a Prime Minister was also unconstitutional because it sought to limit important aspects of government and prime ministerial responsibility to the National Parliament. In other words, the Constitution is not just there to be amended in accordance with its procedures. There are overriding principles of democratic governance which prevail. Other challenges to constitutional continuity have taken diverse forms, and I won't go through the full catalogue, but they obviously include the Rooney Affair in 1979, in which the government found itself in conflict with the then Supreme Court, and the Chief Justice and a number of other judges resigned, or ultimately resigned, and there were widespread public protests. Other tests included in 1993, when Pius Winkby, who was then Prime Minister, sought to evade a possible motion of no confidence by resigning overnight, walking into Parliament the next morning and being re-elected, so that he was then guaranteed a further term. And the court again said that that wasn't quite what was at stake. In 1997, the Sandline Affair represented in many ways the greatest challenge to democratic and constitutional governance that Papua New Guinea has experienced. And what was truly striking was that when the military did intervene, it did not seek to take over. And the government of the day somehow invented something which allowed a Prime Minister to stand aside and somebody else to act in his place. In other words, there's been restraint in some areas, perhaps realism about the prospects of success. And at the same time, there's been considerable innovation, which has allowed for constitutional continuity, with, if not in strict accordance always with the letter of the law. The most significant set of, or the largest set of amendments, in many ways the most challenging set, are of course the amendments to the Constitution, which enacted the Bougainville Peace Agreement and the organic law, which also is part of that, because they guarantee a constitutional, they guarantee a referendum in Bougainville in the period between 2015 and 2020 on a separate independence for Bougainville. And that could constitute the greatest challenge to the national integrity of Papua New Guinea, perhaps to the understanding and acceptance of other states in the region, and of many Papua New Guineans that perhaps Papua New Guinea has confronted since independence. Another testing time for the Constitution was the sequence of events in 2011 and 12, when Sir Michael Somare was removed as Prime Minister while undergoing medical treatment overseas, and Peter O'Neill was elected by the National Parliament to replace him. Again, sections of the military involved themselves. But again, as in 1980, part of the constitutional continuity, I think, was a product of the acceptance by Sir Michael Somare of loss. And in many countries, that's been part of the problem of the constitutional continuity, is getting leaders to accept loss and not to resort the streets or the military or other options. Perhaps it's realism, perhaps it's conviction, perhaps it's a whole range of different factors, but I think it's important. But despite the argument and the supporting evidence I've outlined, Papua New Guinea has acquired a reputation for instability, certainly political, so far as there's no Prime Minister or government since independence has served a full 5-year term, and constitutional, where many of the incidents and experiences outlined are taken into account. It was striking to me that when the Supreme Court announced that the arrangement for asylum seekers in Manaus was unconstitutional, it was reported in an Australian newspaper that Papua New Guinea was now in chaos. So apparently, taking a matter to court, respecting the decision of the highest court and acting in accordance with the Constitution is chaos. That tells you something quite significant, I think, about external perceptions of Papua New Guinea. And a minor footnote to that, Australia's had more Prime Ministers actually in the last 5 years than Papua New Guinea. And in other words, we need to be careful with our metrics. On a related point, a recent book has cast new light on political instability, with which Papua New Guinea is widely identified in the account it provides of an incident which coincided with the independence celebrations in 1975. According to the author, it has recently become known that the Governor-General was in ongoing communication with the head of state during this in Papua New Guinea and her representative during the independence celebrations. And the fear was that these incidents that they were discussing would lead to the dismissal of the Prime Minister. What a drama that had occurred during the independence celebrations. The only problem with this conclusion is that the Governor-General and the Prime Minister, to which the report refers, for both Australians. Perhaps accounts such as those just outlined can be used to promote more careful appraisals of what has been a real achievement in Papua New Guinea. 41 years of constitutional government. There seems to be a strong case for looking carefully at comparisons of measures outside observers in particular employed and encouraging more carefully prepared and formulated assessments. So let me then conclude by saying that I think Papua New Guinea has, as I said, had a long period of constitutional testing, which is not unique to Papua New Guinea. I think it's possible to say that some of the incidents outlined represented a disturbance of the Constitution. Sometimes there was an interruption. I think the Sandline affair represented quite a considerable interruption, and possibly the impasse did too, to the continuity of things. But there has not been a fundamental or lasting disruption of the system of government. In other words, there's been disturbance, there's been interruption, but there has not been complete disruption. And I think this is quite an achievement for Papua New Guinea, and as I say, probably owes a great deal to the very considerable effort put by the CPC into legitimising the Constitution through public consultation. Perhaps I'll finish with a brief anecdote. I remember walking down the street in Bougainville with a younger Papua New Guinean lawyer who turned to me and walked and said, "I wrote the Papua New Guinea Constitution." And I looked at him and I thought, "You're young, you're involved." He said, "Yes, I was a member of the discussion group in my village." That, I think, says something very important about the significance of the process and the continuity, despite the challenges which I've attempted to outline.
Thank you very much.
We are running very close to time. It's been wonderful. No, that's okay. Does anyone have any questions before we finish here today? No?
On the question of independence of Bougainville, Would you care to comment on where that's at? Because we're in the sweet spot at that time where we can exercise that option.
I think we're at that point where there's a lot of technical talk about how to run a referendum. There hasn't been yet, that I can see, discussion amongst national politicians about what the options are that they might be prepared to offer Bougainville, nor a very obvious discussion in Bougainville about what independence might mean. Because if you look, and if it's the only option, it should be there. Because if you look around the Pacific, independence can have very many different meanings. It can mean you still have freedom of movement from other countries. It might mean you do or don't need to have your own universities, your own institutions. There has to be, I've done quite a bit of work on this recently. It seems to me very important that there has to be a dialogue on both sides about, on the government side, what they might accept, on the Bougainville side about what independence might mean, because it might lead to quite considerable changes of opinion, and then there has to be engagement. And although that's been, the possibility of this has been discussed, at the moment we haven't got beyond people who are talking about the distribution of ballot papers, the compilation of electoral rolls and the technicalities. I think it is political engagement that's required. And of course, and that's part of what needs to be factored in, likely to be very considerable external interest in the wider implications for the region of, the upcoming Bougainville and management of the process.
Let me comment the speaker, and just make a comment that in the judiciary and in the legal fraternity, we teach that the Constitution speaks from time to time. So with different generations and different circumstances, the court interpret in the way that the country moved on from where we were. If you look at the Bougainville started the first amendment 1 to the Constitution, and it made one of the largest amendments we will do in the autonomy, and that's what Professor knows about. So, in terms of the Constitution, it's a valve, if you like. It's something that other constitutions look at. And an example is the Fiji Constitution. You can't amend the Constitution. You have to abrogate it. And therefore, you have the overthrow. So that's something good that we have to do.
Any other questions? Yes,
Thank you very much for your additional comment. And just to add one small point to it, one of the striking things that some of the Papua New Guinean experiences earlier, we were talking about the various places I've been, a lot of that has been an interest in the achievements in Papua New Guinea. The Bougainville peace process is regarded as one of New Zealand's most successful such processes anywhere in the world. That's something that I think is worth being proud of. But let me also say it's a particular privilege to have you here, sir, because Shmasi's father was one of the leaders who played an important part in the lead up to independence. I had the privilege of meeting him, and he was also one of the most brilliant orators I've ever seen. And it's a very great pleasure and privilege to have you here today, sir.
well, thank you once again. We can play this in the background. Professor Edward is located in YouTube. No, that's okay. It's right here, ready to go. But I am aware that some of you may need to run. There is plenty of luncheon left, so if anyone wants to partake in some nibbles and talks, please do. I'm going to press play on this. It may be a little loud initially, but I'll run and turn it down in a moment. But thank you so much for joining us here today, and please do stay if you can. Thank you.
You've got 2 or 3 of the same thing up at the same time.
Oh, okay.
So if you close 1 or 2 of those. Yeah.
Thank you.
My students told me that.
Okay.
The final driver of the ceremony, to harden media men and those that are feeling Papua New Guinea over the years. The ruling decided, to those watching closely,